Hello and welcome back to my channel Coinceras. Final approval from the New York court supervising the case is required before the agreement can be finalized. Despite the video's explanation that crypto assets do not exist, the merger would make it impossible for Quan and Terraform Labs to buy or sell crypto asset securities in the future. The SEC has ruled that it will not back an idea that does not yet exist. What occurs here does not change the fact that the settlement still need approval from the presiding court in New York. Moreover, following the agreement's implementation, neither Quan nor Terraform Labs will have the authority to purchase or sell any securities pertaining to Bitcoin. Furthermore, the video notes that the approval of the New York court overseeing the case must be obtained in order to formalize the settlement. This is significant regardless of when the film addresses investment contracts later on, when crypto asset securities really exist. It seems that the SEC is trying to get a final consent judgment on two big fraud schemes involving Terraform Laboratories allowed. Here, the SEC has made this demand following a jury's finding that Terraform Labs Limited was guilty of intentionally and negligently executing one of the most massive securities frauds that the US has ever seen. The legal team representing Ripple has alerted Judge Torres of an increase in Ripple's authority. According to the letter, Ripple is quite proud of the fact that it has never been sued for fraud. Like we saw with Doge, an industry briefly collapsed because to Ripple's involvement in a significant amount of actual fraud. This deserves attention. For this reason, this change is significant. In total, Terraform must fork over $420 million in fines and $3 million to serve as a deterrent. The proposed settlement deal stipulates a figure of $58 billion, and the payment of both amounts is required by the SEC Ripple case. Nobody has lost any money, even though the SEC has used witnesses who lost money investing in Ripple and hasn't claimed that Ripple's consumers lost money either. The SEC may have reached a consensus on the matter, but the proportionality principle dictates that the civil penalty levied in the Terraform case is too high. In terms of pattern compatibility, only Terraform has been successful so far. The Securities and Exchange Commission's proposed civil penalty is significantly higher than that range, even though there are no accusations of fraud and institutional buyers did not incur substantial losses. The legal team at Ripple's has reviewed the SEC's proposal and found that it is unreasonable and unfounded, thus, the court should dismiss it. An appropriate civil penalty would not exceed $10 million, the SEC admitted in the Terraform case, despite their history of prioritizing sensationalism over solid policy. The facts presented here concern the percentage of gross sales and fall within the parameters set by the SEC's threshold for prosecution. The sentence's incredibly disproportionate harshness adds fascination to the Ripple case. When it comes to cryptocurrency exchanges, Ripple is the gold standard. The SEC is aiming for a civil fine much higher than the 6 to 2 range. 1.8% of the defendant's total revenue, as described in earlier SEC instances. This stands in stark contrast to earlier events, which set a precedent. Differentiating this case from others is the fact that the SEC refrained from seeking such a sanction. Bill Morgan, an attorney, has cast doubt on the SEC's stance on Ripple. A penalty equivalent to 1.27% of Terra's total sales was stipulated in the consent judgment for the Terraform case, which was one of the largest securities frauds in US history. Morgan states that the sum is between 1 and 1.5 times the defendant's cryptocurrency gross sales. Ultimately, the Securities and Exchange Commission decided to accept the fine. These widely recognized criteria place this penalty squarely within its bounds. The $870 million allegation that the SEC is presently pursuing is 85 times more than any other fine imposed for cryptocurrency-related infractions during that span, according to Ripple. Morgan asserts that Alwell is in charge of the SSC's Ripple and cryptocurrency projects. To him, this punishment seems unreasonable. On top of that, if they were in charge, the judge would investigate the case suspiciously. This form of punishment is unfair in his opinion. Mark Fagel, a former attorney for the SEC who offered commentary on Morgan's account, stated that the penalty in Terra form is more of an aspiration than an actuality. The reason behind this is that it shows resolved cases instead of real money. In reaction to her essay, Morgan made the declaration. Even while he concedes that the ripple effect is still going strong, the disproportionality is enormous when compared to conventional wisdom. Ruffle CEO Brad Garlinghouse recently made the bold claim that the SEC will likely recover a $100 million penalties before the end of summer. Compared to the SEC's proposal, the sum we are proposing is substantially smaller. Next, Morgan clarified that the judge's ruling only impacted Ripple as a whole and not any individual XRP holders, and that the company was completely innocent in the Terraform case. On the other hand, he did agree that a guilty plea and a settlement should be met with some mercy. An additional attorney named Mark Fagel has asserted that the SEC may not achieve its intended result. On top of that, he purposefully made the waive disproportionate to the standards so it wouldn't settle. Along with the above issues were also raised over attorney Bill Morgan's position on Ripple and the possible results of the Terraform case. Given the SEC's actions in the Terraform case and the continuing legal dispute between Ripple and the SEC, he has determined that the current method is unmotivated and that the degree of disproportionality is far higher than typical. Take a more thorough and careful approach to enforcing regulations. See you in the next video. Bye.